to the U.S. District Court for the District of Columbia. Susan DeClercq, nominated to the U.S. District Court for the Eastern District of Michigan. Judge Julia Munley, nominated to the U.S. District Court for the Eastern District of Pennsylvania. And Judge Vernon Oliver, nominated to the U.S. District Court for the District of Connecticut. Congratulations to all the nominees and their families. There are several members joining us today for introductions. First, I'm going to turn to the ranking member, Senator Graham from South Carolina, for any opening remarks he would like to make.
Thank you, Mr. Chairman. Look forward to the testimony, and let's get on.
Thank you, Senator. We'll hear introductions for our nominees and start with Senator Stabenow, who is here to introduce Ms. DeClercq.
Well, thank you so much, Mr. Chairman and Ranking Member and all the members of the committee. I am really honored and excited today to introduce Susan DeClercq, who President Biden nominated to serve as the U.S. District Judge for the Eastern District of Michigan. She's here today with her husband, Greg Kerr, and their 3 children, Zoe, Colin, and Tabitha. She also has wonderful supporters and friends here, Monica Vilger and Mick Tuesley and Federal District Judge Judy Levy. So we are so pleased that they are all here, and it's fitting that Ms. DeClercq has a wonderful group of supporters here today because she certainly has a lot of supporters in Michigan. One of the things that people consistently say about Ms. DeClercq is how warm and personable she is. She is, in a word, kind. But don't let that fool you. She can go toe-to-toe with anyone in the courtroom. Ms. DeClercq is a proud graduate of the University of Michigan and Wayne State University School of Law. Her first job out of college was serving as a clerk to U.S. District Judge Aaron L. Cohn. Judge Cohn was a force of nature who spent 40 years on the federal bench, retiring at age 95. He was a bit gruff, but he had an open mind and an open heart, 2 attributes Ms. DeClercq has carried throughout a career that spanned the public and private sector. Currently, she is Director and Counsel of Special Investigations at Ford Motor Company. And before that, she spent 18 years in the U.S. Attorney's Office for the Eastern District of Michigan in a variety of leadership roles, including Chief of the Civil Division. She's fought to protect people's civil rights, including, for example, a Michigan family that was kicked out of a restaurant because their children suffered from a genetic skin condition. And she successfully represented an auxiliary firefighter and a U.S. Army reservist who had denied a promotion extended to coworkers with less experience after he returned from active duty in Afghanistan. In all of her cases, she's won the respect of everyone in the courtroom. As one Michigan lawyer said, if I had to lose to anybody in litigation, I'm glad it was Ms. DeClercq. It's worth noting that if confirmed, Susan DeClercq would be Michigan's first federal judge of East Asian descent. Susan DeClercq is an outstanding nominee, and I wholeheartedly support her nomination. I see my partner and colleague, Senator Peters, here as well. We are very enthusiastic and urge the committee to support her. Thank you.
Thank you very much, Senator Stabenow. And now from the University of Michigan side, Senator Peters.
Well, Michigan State as well.
We have 2 Michigan Staters.
Absolutely. Well, thank you, Chairman Durbin and Ranking Member Graham. I'm pleased to introduce Susan DeClercq, an exemplary Michigander nominated to serve on the United States District Court for the Eastern District of Michigan. I want to take a moment to acknowledge Susan's family, and I'm sure my colleague has already done that, but it's worth doing again because they are incredible support for Susan. Her husband, Gregory Kerr, and their children, Zoe, Colin, and Tabitha. Susan's also joined by 3 friends, Monica Bilger, Mike Tuesley, and the Honorable Judge Levy, who currently serves on the U.S. District Court for the Eastern District of Michigan. And I want to join my colleague in thanking them to be here on Susan's behalf. Susan is a graduate of 2 public institutions in Michigan, the University of Michigan and the Wayne State University School of Law, where I attended, and has over 2 decades of experience that will serve her well on the federal bench. In the U.S. Attorney's Office for the Eastern District of Michigan, she defended the United States against a broad range of litigation and argued civil rights cases on behalf of the U.S. government. This civil rights experience was paramount. Susan spent 12 years bringing cases involving the Fair Housing Act, the Equal Credit Opportunity Act, and much more. At one point, she conducted a lengthy investigation into one of the largest child care providers in the country, and she helped uncover violations of the Americans with Disabilities Act, leading to policy changes that ensured that diabetic children at hundreds of child care centers across the country could receive the care that they needed. Susan's extensive work for our nation's service members and veterans is also deeply admirable. Her work for the U.S. Attorney's Office allowed her to represent service members personally, bringing numerous cases to protect and enforce the rights of members of the military under laws such as the Service Member Civil Relief Act and the Uniformed Services Employment and Reemployment Rights Act. And finally, the breadth of Susan DeClerc's work illustrates her commitment to balance and fairness, from her extensive civil rights work to representing businesses in high-stakes investigations to defending the U.S. government against litigation brought against it. She has a range of experiences that will be key to effectively serve on the federal bench. Susan DeClerc is an accomplished legal professional with the experience, the qualifications, and temperament necessary for this role, and I have every confidence that she will be confirmed by the Senate. On the federal bench, she would not only be an exemplary model for our state, she would also be Michigan's first federal judge of East Asian descent. And I'm proud to support her nomination to serve on the United States District Court for the Eastern District of Michigan. Thank you.
Thanks, Senator Peters. Of course, we understand you and Senator Stabenow and your colleagues have a pretty busy schedule, so if you would like to move on at this point, you're certainly welcome to. Thank you for joining us. And now to continue Scranton Day in the Senate Judiciary Committee, Senator Robert Casey.
Chairman Durbin, thank you very much, and I want to thank you and Ranking Member Graham for this opportunity, and members of the committee for being here today and for the work you do to advance judicial nominations. I'm proud to introduce Judge Julia K. Munley to the committee, someone who has served our county of Lackawanna, my home county, as well as people well beyond that county in the region for so many years. I'm especially grateful that she's willing to serve as a judge on the United States District Court for the Middle District of Pennsylvania. I want to thank in particular her family who's with her today. I won't mention every member of the family, but her husband Pat is right over my left shoulder. Next to him are both Marion Munley, her cousin, and her husband, United States Representative Matt Cartwright. We're always grateful when a member of the House gets to come over here and say hello to us. We don't get over there enough. So Matt, welcome. I want to thank as well Senator Fetterman for his partnership and his support of Judge Munley, and I look forward to continuing to work with Senator Fetterman to advance judges throughout our three federal judicial districts. Judge Munley is a graduate of Marywood University, one of the great institutions of higher education in northeastern Pennsylvania. Too many members of my family have graduated from that institution to mention here today, but I'll mention two, my daughter and my mother, so I'm putting in a little commercial there. She's also, of course, a graduate of the Dickinson School of Law, one of the great law schools in our state. She's been a lawyer and an advocate when you cover the time as a lawyer and as a judge for the last 30 years. As an advocate for workers, for seniors, for people who sometimes don't have a voice, for victims of sexual assault and harassment. So many members of our community came to her for legal representation, and she represented them with honor and distinction and professionalism. She became a member of the judiciary in 2016, appointed by Governor Wolf to the Court of Common Pleas in Lackawanna County, the county bench in the 45th Judicial District. In those 7 years, of course, she's had to deal with all kinds of matters, civil and criminal, and so many difficult matters that come before a judge. That experience, combined with her life experience, her experience as a lawyer and advocate, prepare her well to take on the duties to be a United States District Court judge. I have no doubt at all, that she has the integrity, the ability, the vast experience, as well as a commitment to the rule of law and equal justice under the law to serve the people of the Middle District with distinction. And finally, let me make one final note about her family. Her family has a long tradition of public service, several generations serving in the General Assembly of Pennsylvania. I want to mention in particular her father, Judge James M. Munley, whom we lost in 2020. Like Julia Munley, Judge Munley, he served as a member of the Court of Common Pleas in Lackawanna County, as well as a United States District Court judge. I'm honored that she's willing to follow in that tradition of quality public service infused with the integrity that we should expect of every public officials, especially our judges. So, Mr. Chairman, Mr. Ranking Member, we're honored to introduce Judge Munley.
Thank you, Senator Casey. Judge Oliver from Connecticut has two people here to introduce him. On the panel, of course, is our colleague, Richard. You are from Connecticut, are you not? Richard Blumenthal and Honorable Chris Murphy. We'll start with Senator Blumenthal.
Thank you very much, Mr. Chairman. Thank you for affording us this opportunity to be here today with some really exceptionally qualified nominees, thanks to President Biden, and I'm pleased to be here with my great friend and colleague, Senator Murphy. The two of us strongly support Judge Vernon Oliver for this position. It's a point of particular personal pride and joy for me because I have known Judge Oliver for close to 20 years. He was born in Bridgeport, Connecticut. After receiving his BA and his JD from the University of Connecticut, he worked briefly in private practice and as a temporary assistant clerk for the Hartford Judicial District. He then was a prosecutor in the criminal division of criminal justice, and then was hired to serve as an assistant attorney general in the Connecticut Attorney General's office. I happened to be attorney general at the time. I served with Judge Oliver for 5 years, and I came to know him personally as a vigorous, skilled, and aggressive advocate, but also as a person of extraordinary compassion and insight. He served as a senior member of our division on child abuse and neglect. These cases are challenging beyond words. They involve the fate of children who may be abused or neglected, often the need to terminate parental rights. He handled those cases with adroitness and insight, and vindicated the interests of those children along with the interests of the state of Connecticut. He was appointed in 2009 by Republican Governor Jody Rell to serve on the Connecticut Superior Court, and throughout his 15 years on the bench, he presided over numerous civil and criminal trials, in fact, 300 bench trials, and about 20 jury trials, thousands of hearings, made maybe tens of thousands of rulings. So he is extraordinarily experienced and impressive in his judicial career already, and he's been supported by Connecticut attorneys as well as Republican members of the House, State House of Representatives, and other organizations involved in our profession. So I'm very pleased and proud to support Judge Oliver, and I look forward to his speedy confirmation.
Thanks, Senator Blumenthal. Senator Murphy.
Thank you very much, Mr. Chairman, Ranking Member Graham, members of the committee. Thank you for allowing us the opportunity to introduce Judge Oliver to you. I won't repeat his, I think, very impressive resume, except to say that it's hard to be more committed to the state of Connecticut than Judge Oliver has been, having gone to Bridgeport Public Schools, attending the University of Connecticut as an undergraduate and as a law school student, and then dedicating, as you heard, his entire career to protecting the people of Connecticut and protecting the rule of law in Connecticut. I will just bring your attention to the ways in which Judge Oliver has done some of the most difficult and some of the most important work in our judicial system. Senator Blumenthal has already mentioned the work that he did as an Assistant Attorney General in the Child Protection Bureau, maybe the hardest work that you can do in an Attorney General's office. And Judge Oliver did it enthusiastically and adeptly. But I want to mention a couple things that Judge Oliver has done during his time on the bench. Yes, he has presided over 300 cases. He was nominated by a Republican governor to that post, getting broad bipartisan support. But at a moment when we are trying to explain to the American public the relevance and the independence of our judiciary, Judge Oliver has taken on a couple tasks that I think are really important you should know about. First, he actually spends a lot of time outside of the courtroom talking to student groups, high schools and middle school students, about his work and why they should believe in Connecticut's judicial system. He also spends time talking about his journey from Bridgeport, from the Bridgeport Public Schools, to one of the highest positions in state government, encouraging more students to pursue a career in law. Second, Judge Oliver serves as the chair of the Connecticut Committee on Judicial Ethics. Now, we know it's often hard to find senators to serve on the Ethics Committee here. It's not a job you normally sign up for, but Judge Oliver is not just on that committee, he's the chair of it. He's taken on a really tough job to lead the efforts to make sure that we are applying the rule of law not just to those who appear before the court, but to the judges themselves. And so I just make those two notes for you to show you that this is a pattern in Judge Oliver's career, doing some of the most difficult and most important work to maintain the integrity of our judicial system. So I'm very proud to join Senator Blumenthal in introducing Judge Oliver to the committee. I'm confident that you will find him to be as impressive as we have, and I look forward to working with you to bring his nomination to the Senate floor. Thank you very much, Mr. Chairman.
Thanks, Senator Murphy. Of course, I understand you have a busy schedule, too. We're grateful that you could be here today for this hearing. Thanks to all the visiting introducers. It's my honor to personally introduce Judge Ali Khan, who's been nominated to the U.S. District Court for the District of Columbia. Judge Ali Khan is a graduate of Bard College at St. Simon's Rock and the prestigious Georgetown University Law Center. After law school, she served on the U.S. District Court for the Eastern District of Pennsylvania and on the Third Circuit Court of Appeals. Judge Ali Khan then served as a Bristow Fellow at the Department of Justice, spent 3 years in private practice, working at O'Melveny and Myers here in D.C. In 2013, Judge Ali Khan joined the Office of Attorney General for the District of Columbia as Deputy Solicitor General. After serving as the Acting Solicitor General, Judge Ali Khan became the district's Solicitor General in 2018. During her career as a practicing attorney, Judge Ali Khan argued in the Supreme Court of the United States and in the U.S. Court of Appeals 12 times, federal district courts 6 different times. In February of 2022, the Senate confirmed Judge Ali Khan to the District of Columbia Court of Appeals on a bipartisan basis. She's shown an even-handed approach from the bench. At the request of Congresswoman Eleanor Holmes Norton, I'd like to enter the statement by the Congresswoman in support of Judge Ali Khan without objection. I welcome Judge Ali Khan and her family and look forward to her testimony today. We're now ready for the nominees' opening statements. If the 4 nominees would approach the witness table, and raise their right hands once they're in place. Do you affirm the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Let the record reflect that, thank goodness, all 4 answered in the affirmative. Judge Ali Khan, you're first.
Good morning, Chair Durbin, Ranking Member Graham, and members of the committee. I am grateful and humbled to appear before you today as you consider my nomination. I thank President Biden for the honor of this nomination, Congresswoman Eleanor Holmes Norton, and members of her Federal Law Enforcement Nominating Commission for recommending me to the President, Chair Durbin for the warm introduction, and the hardworking committee staff for making this hearing possible. I would like to take a moment to introduce a few important people in my life. First, my husband, Justin Noble, whose patience, encouragement, and support of all of my personal and professional endeavors has been unparalleled. Next, my parents, Dr. Mahmood and Linda Ali Khan, and my sister, Leah. My father was born in British India, and after independence and partition, he made his way to Pakistan before coming to the United States and settling in Baltimore, Maryland. Without my family's sacrifices and without the opportunity that only this great country can provide, I would not be sitting here today, one generation removed from colonial rule, and my father would not be sitting here behind me. I had the incredible good fortune to begin my legal career as a law clerk to Judge Lewis Pollack on the District Court in Philadelphia and Judge Thomas Ambrose on the Third Circuit. I can imagine no better judicial role models for a young lawyer, and I have carried the lessons I learned from both throughout my career and onto the bench on the D.C. Court of Appeals. Judge Ambrose is here today, and I know Judge Pollack is here in spirit. In fact, my husband is wearing a tie that belonged to Judge Pollack that his wife, Kathy, had made for him several years ago. I am also joined by friends and colleagues spanning my time at the Justice Department, in private practice, and at the Office of the Attorney General for the District of Columbia. These are lawyers who embody hard work, integrity, and kindness, and from whom I have learned so much. Finally, I am joined by members of my court family, including Chief Judge Blackburn Rigsby. I am so grateful to my incredible colleagues on the D.C. Court of Appeals, to the hardworking staff that keep the wheels of justice turning, and to the law clerks and interns who have made our chambers a vibrant second home. Thank you again for the opportunity to appear before you today, and I look forward to your questions.
Thanks, Judge Ali Khan. Mr. Clerk?
Thank you, and good morning, Chair Durbin, Ranking Member Graham, and all members of this committee and their staff. It is a privilege to be here today. I want to extend my sincere thanks to President Biden for the great honor of this nomination, and I am particularly grateful to my home state senators, Debbie Stabenow and Gary Peters, for their recommendation and faith in me, as well as their warm introductions today. I am joined here today by my wonderful family, my husband Greg, who I want to thank for always supporting me and for running our household and keeping us fed throughout this whole process. And our three children, our oldest daughter Zoe, who just finished her first year at Michigan State University, our son Colin, who will be a senior in high school next year, and our youngest Tabby, who is missing out on her last middle school track meet to be here with me today. I love you all more than life itself. Also here with me are my childhood best friend and my dear friend Mick Tousley, and I am also thrilled to have my mentor, my role model, and my dear friend, Judge Judy Levy. She has been an inspiration to me, and I look forward to being judicial colleagues if I am fortunate enough to be confirmed as a district judge. My mother, Marcia DeClercq, and my stepfather, Christian and Iyer, could not be here with me today due to health issues, but they are here with me in spirit, and I know that they are watching me with pride today. I also want to mention my wonderful in-laws, Judy and Mike, who are also joining us remotely, as well as many other family members, friends, and neighbors. I'd like to thank my wonderful colleagues at Ford Motor Company, who have been gracious and supportive, especially my amazing team of investigators and Assistant Carolyn, who are a joy to work with every day. And lastly, my longtime friends and colleagues at the U.S. Attorney's Office in Detroit. You all know who you are, and I could not have done this without you, and I'm so proud to represent the amazing lawyers in the often overlooked Civil Division. Sitting here today, I am both awed and humbled at the journey that my life has taken. From being left on the steps of a hospital in Seoul, South Korea, a place that my birth mother knew that I would be found, to being adopted by my mom in the United States, who raised me as a single parent for most of my life, I am acutely aware that I could not have the life or opportunities that I have had without both of these remarkable women. I have spent most of my career in public service as a way to give back to the people and the country that has given me so much. And I welcome the opportunity to possibly serve again, this time as a United States District Judge. Senators, thank you for considering my nomination, and I look forward to answering your questions.
Thank you, Mr. Clerk. Judge Munley.
Thank you, Mr. Chairman, Ranking Member, and committee members. Today is the greatest honor of my life to be before this esteemed committee. I want to personally say thank you to Senator Casey for your kind words, and thank you, Senator Casey and Senator Fetterman, for your confidence in me. To President Biden, I am so honored by your nomination. I want to recognize those who are here with me today who've supported me along the way. First and foremost, my husband, Patrick, without whose enduring support and encouragement every day, right from the beginning, I would not be here without you. Thank you, and I love you. To my sister, Gwen, and my niece, Neve, I love you. Thank you for always being supportive and making me laugh. You are great. To my cousin, Marion, who is like a sister to me, I love you. And Matt, thank you both. To the two persons who I really would not be here without, who taught me about the importance of integrity, hard work, and family. My mother, Dr. Kathleen Munley, who is watching from home. Keep saying prayers, Mom. I love you. And to the one who would have absolutely loved to have been here today before you, senators, my dear father, United States District Court Judge James Munley. He is with me today, watching and rooting from above. To all my relatives, my loved ones, my cousins, the Munleys, my Aunt Bernadine, the Rogans, my in-laws, can't mention them all, they're too many. To Alice, who helped me so much from day one, Louis, who's always been there, my beloved friends from home, Archibald, Scranton, Northeastern Pennsylvania, my colleagues on the Court of Common Pleas, the members of the Lackawanna Bar Association, my staff members, and all who have submitted letters on my behalf. I thank each one of you for your words of support and your encouragement throughout this process, and to those who have gone before me and paved the way. I owe you so much. Senators, I truly appreciate this committee's consideration of my nomination and look forward to answering your questions today.
Thank you, Judge Munley. Judge Oliver.
Thank you, Chair Durbin, Ranking Member Graham, and members of this committee for scheduling and holding this hearing. Thank you to Senators Blumenthal and Murphy for the generous and kind words, continued support and encouragement, not only this morning, but over the years. Thank you both also for recommending my nomination. Thank you to President Biden for this nomination. It is truly the honor of a lifetime. I'd also like to thank the people of the state of Connecticut for the privilege of allowing me to serve them these past 14 plus years as a Superior Court judge, and prior to that, at the offices of the Attorney General and with the Division of Criminal Justice. I wish to introduce my family. First, Anne, my wife of 19 years. You are my foundation and most trusted confidant. My 17-year-old daughter, who will be entering college in the fall, and my 16-year-old son, who's a high school junior. You are both my inspiration and make me proud to be your father every single day. I would like to thank my family and friends watching from Connecticut and all across the country, as well as my many mentors and colleagues, both past and present, for their guidance throughout the years. Hello to the Middlesex Courthouse staff back home, continuing to do the people's business while I'm here before this committee. Finally, I wish to honor the memory of my late parents, Thelma Marie Gadsden and Willie Oliver, who came north from South Carolina and Alabama, respectively, found each other in Connecticut, and made a large, loving, blended family. I'm honored to come before this committee and ask humbly for your support so that I might continue to serve the public as a district court judge. I'm happy to answer any questions you may have.
Thanks, Judge Oliver. We'll have 5-minute rounds for each senator, and I'll start. It's interesting, I can't tell you how many times I've heard nominees come before us and tell their stories. And there are some recurring themes that always strike me, not the least of which is a salute to talent and hard work that each of these nominees and so many others bring to this room as they pursue their judicial careers. Also, salute to families. Over and over again, we hear from nominees how one family member especially, or perhaps two, stood behind them at a critical moment in their lives and made the difference in their decisions on going forward. And I can't help but note, at least with two of our nominees today, also a salute to immigration. Immigration is what made America. My mother was an immigrant to this country, and I serve as chairman of the Senate Judiciary Committee. I hear on the stories of Judge Ali Khan what your parents and others in your family went through coming to the United States. I'm sure a treacherous journey in many ways, but the determination to come here and succeed and the pride that they take in seeing the next generation become leaders in our nation. Mr. Clerk, what an amazing story to be abandoned as a child and then to be part of a family of adoption that made the difference in your life and brought you to this moment in history. There's a lot of things said about immigration by politicians these days, but I hope that we'll have some honest reflection by all of us, the fact that immigration has made America what it is today, as far as I'm concerned. Judge Munley, I listened to Bob Casey, who's a dear friend, and John Fetterman, who supports you as well, and I heard the story of your family. I was particularly struck by one incident in your life I'd like you to comment on. In private practice, you represented an emergency responder exposed to toxins and debris while working at Ground Zero in the disaster site at the World Trade Center after 9/11. You ultimately helped him recover an award from the 9/11 Victim Compensation Fund to compensate him for the health issues that he faced. Could you tell us a little bit about that experience and what it meant to you?
Thank you, Senator, for that question. It was an honor to represent that individual and to do that pro bono work. That gentleman left Luzerne County a day or two after 9/11 and threw caution to the wind without a care for his own well-being, got in a car and drove to New Jersey and made his way over to Ground Zero to help persons in any way he possibly could. And I had the honor of representing him right from the beginning through the process, gathering witness statements, interviewing individuals, getting all of his medical records to support the serious pulmonary injuries he sustained at Ground Zero. He gave everything during those days. It brought me back to the whole reason why I went to law school, to give back public service. If I have the honor of being confirmed, this would be a continuation of my life's commitment to public service and upholding the rule of law.
Thank you. Judge Ali Khan, as I look at your background as a Deputy Solicitor General and Solicitor General, you've had litigation experience which few nominees bring to this table. I noticed that there's somewhat of a fraternity or sorority of Solicitors General across the country, and many of them have written in support of your nomination, even those of the opposite political party. What is it that you believe guided you in that pursuit?
Thank you, Senator. I was so fortunate to work with an incredible group of public servants across the country. And I think we all served different attorneys general. We knew that what united us was greater than what divided us, and that when we could come together and speak with one voice, it'd be a very powerful voice. Obviously, we oftentimes were on opposite sides of the litigation because we served different attorneys general with different priorities. But when we did that, we were on opposite sides of the V. We litigated with good faith and good humor. I think that public service is so important, and having the opportunity to work not just with dedicated public servants in the District of Columbia, but across the country has been just absolutely the opportunity of a lifetime.
And in all candor, you've been drawn into some political issues in your capacity, have you not?
Yes, Senator.
And it's interesting to note that the Solicitors General who support you are both political parties.
Yes, Senator. We have a wonderful fraternity or sorority, as you said. I think one of the last briefs I filed before joining the bench had 39 state signatories, and I'm very grateful to have the bipartisan support that I do from that community.
Judge Oliver, many of my friends who are practicing attorneys long for the day and just have vague memories of an actual trial experience. It seems to be a hard thing to come by these days. I read here you've presided over approximately 320 cases that have gone to verdict or judgment, so you've seen your fair share of trials. Could you comment on that experience?
Thank you for the opportunity, Senator. I think the right to a jury trial, whether civil or criminal, is really at the foundation of our justice system. One of the things I would look forward to, or I'm so fortunate to be confirmed, is continuing to try jury cases, civil or criminal. In Connecticut, it's a bit of a lengthier process. In the federal district, it's a quicker process. Regardless, I think it's important that individuals, frankly, who have better things to do with their time nonetheless come in and dedicate themselves to the task of judging facts of complete strangers, taking the law from someone they haven't met before, judging credibility from individuals they haven't met before, deliberating to a common purpose in light of their experience, reason, and common sense, and attempting to reach a unanimous verdict on issues of guilt or not guilt or liability. I think it's so important, and I was fortunate to be able, in my time of public service, to take part as a prosecutor in about 24 criminal jury trials, and as a judge in about 300 bench trials, and then as a judge about 24 more criminal and civil jury trials. It's something I'm proud of. I think it's something that's important and necessary, and I look forward to the opportunity to continue to do so on the federal level.
Thanks, Judge. Senator Graham.
Thank you very much. Judge, Ms. Khan, Ali Khan, you were the solicitor for the D.C., is that right? Solicitor General for D.C.?
Yes.
One of the issues you got involved in was Safe House versus DOJ. Do you remember that?
Yes, Senator.
And I think you took a position advocating for safe injection sites for drug users.
The position that we took in that brief that was joined by, I believe, 15 or 16 states was that the opioid crisis affects different jurisdictions differently, and we're all trying and should be looking to novel solutions. And Philadelphia thought that for the nature of its opioid problem, that a safe injection site might be one of those novel solutions. And so as states that are all facing the terrible ravages of fentanyl and heroin, we wanted to give them that latitude and support their ability to experiment in ways of curbing this crisis.
You think there's a safe way to take fentanyl?
Senator, our brief was not to recommend any particular type of safe injection site. It was to say that if Philadelphia thought that that was one way of assisting their community with the opioid crisis, that they should have the latitude.
Would
to do
you be
that.
okay with a state basically allowing people to take fentanyl under state supervision?
Senator, until we are able to get the opioid crisis under control, I think we need to give users
Do you think that's
the
getting
resources
it under
they need.
control, allowing state supervised use of one of the most deadly drugs known to man?
The site that Philadelphia had proposed had treatment services. It had overdose prevention.
How do you view fentanyl?
I think fentanyl is a nationwide crisis, Senator.
I mean, in terms of the danger fentanyl presents to an individual, those surrounding the individual.
I think it's quite dangerous.
Okay. All right. I'm sure Senator Hawley will ask you about the Evangelical Lutheran Church, so I won't take any of his time. Ms. Munley, Judge Munley, we have some common friends. Don McGann, is that a family friend? Is that correct?
My nephew.
Okay. Well, I guess you can still be friends and having it.
He's a friend.
Okay. Bottom line, you have very little criminal practice. Is that true?
Senator, over the course of my 20 years as a trial lawyer, I handled criminal cases. I handled DUI cases. I sat third or fourth chair in a bench murder trial and did all the brief writing for that, including the appellate brief writing, as well as handling criminal juvenile cases.
So you feel like you're conversant in criminal law?
I am completely confident, Senator, if I have the honor of being confirmed in handling any criminal case that comes before me as a trial judge. I've handled criminal cases to verdict, so would be completely confident in handling any criminal case assigned to me.
Thank you very much.
Senator Blumenthal.
Thanks, Mr. Chairman. I want to just begin by echoing the chairman's remarks about the extraordinary impressiveness of this panel and, frankly, of many of the nominees who have come before our committee who have been nominated by the president to both the district court and appellate court. Your story is not only of talent and hard work, as the chairman said, but also of overcoming obstacles. And the diversity that you represent has been part of your life story in a way that is very, very profoundly important to the work that you will do, because you are the face and voice of justice in America. Very few litigants go beyond the district court. Having litigated often in our federal courts, I know how difficult it is to go beyond the district court in cost and time and representation, and you will be the last source of justice for many Americans, countless Americans, the face and voice of justice. And so I just want to say how proud I am that you look like America and that you will no doubt think like America in your common sense and judgment. I want to ask you, Judge Oliver, you have served with extraordinary distinction in our state justice system and on our state bench. How does that state court experience prepare you to be a federal judge?
Thank you very much for the question, Senator. Mechanically, both as a prosecutor dealing with criminal trials, in every trial there's an issue of federal law, whether it's the Fourth Amendment with Mapp versus Ohio and the exclusionary rules applied through the states, and there's Brady versus Maryland, obviously that continuing obligation and duty of the prosecutor to disclose exculpatory information, down to Giglio with the impeachment requirement. And then on the state court bench, in my 4+ years litigating habeas petitions, again, the Sixth Amendment right to effective assistance of counsel, again with those petitions, the Eighth Amendment, a prohibition against cruel and unusual punishment. I've dealt with constitutional issues at the state court level continuously for the past 14+ years. Procedurally, I am committed to doing what I've done the past 14+ years as a state court judge, giving the litigants a fair hearing on the merits, being impartial and neutral arbiter, researching the law, finding facts, restraining myself only to the task before me.
You mentioned one of the differences between our Connecticut system and the federal system, which is in jury selection. There's a very elaborate voir dire process in our state courts involving individual questioning of jury. In the federal system, it is much more pro forma, much more streamlined. You know, I attend a lot of immigration and naturalization hearings where we talk about new citizens and the privileges of citizenship, the right to vote, and the right to serve on juries. And I think you would agree with me that people should feel privileged to serve on juries. Would you agree?
I absolutely would, Senator. Thank you. I tell the jury, the larger jury panels, when I address them in the morning before jury selection, that it is both a burden and a privilege of citizenship. Connecticut has recently, in its attempt to expand the diversity of jury pools, including those who are lawful permanent residents, to those who are eligible for jury service. And so I have selected, as a prosecutor, many juries, as a judge, many juries, whether they ultimately went to a verdict. And I've not yet found a jury, despite the difficulty of the underlying charge, whether it's murder or sexual assault, I've not found a jury that has not come out better, in their own words, better for having gone through the process and developed an appreciation for the importance of a jury of one's peers.
Thank you. Judge Ali Khan, Senator Graham asked you about a particular case and a position that your office took in that case. The Office of Attorney General for the District of Columbia is the equivalent of the State Attorney General, correct?
Yes, Senator, it is.
And the positions taken by your office in any litigation, with all due respect to Assistant Attorneys General or even the Solicitor General, are determined primarily by the Attorney General, correct?
Senator, that is quite correct. The Attorney General sets the litigation priorities for the district, including multi-state and amicus briefs.
Thank you. Thanks, Mr. Chairman.
Senator Kennedy.
Thank you, Mr. Chairman, and congratulations to all of you. Mr. Clerk, do you believe in stare decisis?
Absolutely.
Tell me what that is.
Is to follow precedent.
Okay. If you're confirmed, will you follow all higher court precedent?
Yes. I pledge to this committee that if I am confirmed, I would follow all Supreme Court, Sixth Circuit precedent.
Okay. Would you have followed the Dred Scott case?
Boy, there are some foundational cases where there
Yes, ma'am.
is-
Let's just start out with the basics.
Sure.
If we could. Would you have followed the Dred Scott case?
As a federal lower court judge, I would have been obligated to follow that case
So
as
you would have?
precedent.
You would have?
If I had been a lower federal court judge, I would have been obligated to do so unless the.
That's a yes? There are only
there-
two doors here, yes or
Yes.
no?
If I had been a judge at that time, I would have been obligated to do so, yes.
Okay. Would you have followed Plessy v. Ferguson?
Again, your Senator, as a lower court federal judge, if I were to be confirmed as a district court judge, I would be obligated to follow all the Supreme Court precedent. If the Supreme Court determined that there was a precedent that it found that it should overrule, they have that opportunity to do so, but as a lower court judge, I would be obligated to follow it.
That's a yes?
Correct. Correct.
Okay. Judge Ali Khan, am I saying that right?
Yes, Senator.
Okay. Will you allow your personal or political beliefs to affect your decisions?
No, Senator. My personal beliefs have never played a role in the positions I took as an advocate, nor do they play a role in the positions I take as a judge when I'm neutrally deciding a case.
Okay, I'm glad we got that off the table. Let me ask you a few questions about how you view the world. Do you believe that minorities need special help to succeed?
Senator, that issue is currently pending before the U.S. Supreme Court.
Yes, ma'am, but we just established that you're not going to let your personal opinions affect your decisions. You're going to follow precedent.
Absolutely, I will follow whatever
Okay.
precedent comes
So let's
from the
talk
Supreme
about your
Court.
personal opinions, which will be irrelevant to your position on the court. Do you believe that minorities need special help to succeed?
Senator, again, I don't have a personal position, and sitting here as a current sitting judge and
Have you
as
thought
a
about
nominee,
that? Have you thought about that?
I am aware that we have given preferential treatment. It's been subject to a lot of different court cases. The
Okay, do you
issue,
agree with that or disagree with it?
it's not a question, Senator, of whether I agree or disagree. I
Sure it
apply the
is.
law
You're-
as it comes before me.
You're being confirmed to the federal bench, and presumably you're a critically thinking person. I'm just asking you what you believe. Let me ask you one more time. Do you believe that minorities in America need special help to succeed? It's a very simple question.
Senator, to the extent policymakers have enacted laws that provide protections,
Do
I
you
would
agree with
faithfully-
those policymakers?
I am not a policymaker, and as a sitting judge, it is...
You don't have an opinion, or you're just not going to answer. I don't want to waste more time if you're not going to answer.
Senator, as a sitting judge, it is inappropriate for me to
No, it's
comment
not.
on my personal views.
No, it's not. We've already established that you're not going to let your personal beliefs interfere with your decisions, so I think you ought to tell us what your personal beliefs are. Do you believe that do you believe in systemic racism?
Senator, again, that's a question for sociologists and academics. I take
You
every
don't have
case-
an opinion, you never thought about it.
I take each case as it comes before me on the individual facts.
What is systemic racism?
My understanding is that it's a sociological theory that racism plays a systemic role. But beyond that, I'm not an academic, I'm not a sociologist. I am a judge, and I apply the facts and the law to the cases that come before me.
Right, but you don't have an opinion.
No, Senator, I do not.
Do you have an opinion on anything you'd like to share with us?
Senator, as a sitting judge, it's inappropriate for me to comment on any personal views I might
No, it's
hold
not. We
because
just
I would not.
established, the first question I asked you was, your view of the world does matter. If you never thought about the world, if you never thought about these issues, you're not qualified to be a federal judge. And I think you ought to come here and answer. I think all of you should come here and answer them forthrightly. If I ask you, let me ask you one last question, and I will quickly, Mr. Chairman. Do you believe, you sit on the District of Columbia Court of Appeals. Is the District of Columbia Court of Appeals systemically racist?
Senator, as a sitting judge, I think it would be inappropriate for me to comment. I can say all of my colleagues take the cases open-mindedly
But do
and
you
on the
think it's
facts that are before them.
systemically racist?
I don't think that it is, Senator, but I also
Okay.
don't know if I'm qualified to give that type of
Well,
assessment.
you sit on the court, right?
I think all of my colleagues take their cases with an open mind, without any prejudice, and faithfully apply the law to the
Well, I'm
facts.
disappointed you won't answer my questions, but I thank the chairman for giving me the extra time.
Thank you, Senator Kennedy. Senator Hirono.
Thank you, Mr. Chairman. I want to acknowledge the fact that President Biden has nominated some of the most diverse nominees, highly qualified nominees to all of our courts, and diversity and inclusion is really critical. And I see, at least in two of our nominees this morning, that they are not far from the immigrant experience, which I think is a very critical part of inclusion and diversity on our courts. And again, as the only immigrant serving in the U.S. Senate, I think I have many life experiences that are common to our two nominees. And to all of our nominees, thank you very much for your willingness to continue public service. I'd say that when we ask questions such as the import of Plessy, Dred Scott, Korematsu, these are decisions that are fine examples of how the Supreme Court gets it really, really wrong. And I would say some of the court's decisions now will fit into that category, and it may not take that long for history to make that judgment. I asked the following two initial questions to ascertain the fitness to serve of every nominee who comes before any of my committees that I sit on. So I will ask each of you those two questions, and we'll start with Judge Ali Khan. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No, Senator.
No, Senator.
No, Senator.
No, Senator.
Have you ever faced discipline or entered into a settlement relating to this kind of conduct?
No, Senator.
No, Senator.
No, Senator.
No, Senator.
Judge Oliver, I really appreciate the fact that you talk with students about citizenship. I think that is something that we, all of us, should be focusing on, especially, and talking about, especially as I believe that the ability for people to vote, which is a basic and fundamental right of citizenship and responsibility, I believe there are too many states that are really limiting our right to vote. So thank you very much for taking the time to talk to our young people and encourage them to be aware of public service. So in your Responsibility Committee on Judicial Ethics, why are judicial ethics and judicial integrity important to our justice system?
Thank you for the question, Senator. I think the short answer is when the people are aware that the judges whom they come before are governed by a rule of ethics, they have more faith that the judges police themselves, and that when there's a situation where a judge's impartiality might reasonably be questioned, that judge would step aside. So it restores and continues, bless you, Senator, restores and continues faith in the criminal justice system by the litigants who come before us.
Thank you. I completely agree with you. Judge Ali Khan, you have spent thousands of hours on pro bono work. Can you just tell us why the pro bono work has been so important to you?
Thank you, Senator. There are so many litigants in this country that don't have the benefit of representation. Obviously, we have enshrined a right to counsel in criminal cases, but there are many civil cases, collateral proceedings, where there's not a constitutional or statutory right to counsel. And I think as lawyers, we owe an ethical duty to our legal community to represent those that cannot afford representation, both because it, I think, helps advance the interests of those individual litigants, but it also serves the court. I have been fortunate to be appointed by both the Third Circuit and the Sixth Circuit to handle cases where they felt that the use of counsel would be helpful.
Thank you. Judge DeClercq, the fact that you have a very unique background, to say the least, has being an immigrant been one of the reasons that you wanted to become a lawyer? And does it inform the how you approach decision-making as a judge?
Yes, I'm very proud of being an immigrant. It is a more unusual immigrant experience in that I was brought to the United States as an infant and adopted by my family. But I've always been very aware of how different my life would have been had that not happened, and the incredible opportunities that this country has given to me. And so I've spent most of my professional career in public service. I deeply appreciate not only the country, but the government, which was why I joined the Department of Justice. And for me, it's always been about equality and justice, and I think that that is part of the immigrant experience.
Yes. I think you are another example of immigrants coming to this country to create a better life, but the appreciation we have for a country that afforded us opportunities we never would have otherwise had. I just want to mention, Mr. Chairman, for Judge Munley, it must be an incredibly meaningful experience for you to be sitting here to be on the court that your father served.
Thank you, Senator. It truly is an honor. He taught me about what it is to be a good judge. He served as such an example to me of what it means about judicial temperament, and I consider that one of the most important attributes for a judge.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator Rono. And now, Senator Blackburn.
Thank you, Mr. Chairman, and congratulations to each of you on your nomination. Judge Alican, I want to come to you. Some remarks you made when you were Solicitor General in D.C. to the American Constitution Society event. And you said, and I'm going to quote you through this, that it was in your job you try to carry out and live some of the values of ACS. And here's a portion of the mission statement for ACS, and this is off of their website. It states that ACS mission includes redressing the founding failures of our Constitution and enduring inequities in our laws in pursuit of realized equality. So, in your role as both an advocate and now as a judge, do you subscribe to that part of the mission statement, and what do you see as the enduring inequities in the laws that need to be redressed?
Senator, when I said as Solicitor General that I carry out the values of ACS, it was the values of mentorship and discussion and vibrant discussion and debate.
So then you don't agree with what is on their website? So here's another part for you. It also notes on their website that its goal is to promote laws and policies that advance realized equality. So what laws and policy are you trying to promote, and then is this part of what you're trying to carry out? Is it activism as a judge that you're seeking? So as a federal judge, what would that look like if you're trying to live this out, if you're trying to carry it out, if you're trying to change those laws?
Senator, as a judge, it is not the role to change laws. It is to interpret and apply the laws that this body passes.
Well, in your comments, that's what you said. I'm quoting you, back to you. So how would you advance realized equality from the bench?
Senator, in my current role, I take the law and I apply it to the facts and cases before me. That is what I would do if I were fortunate enough to be confirmed.
Okay, so how would you fulfill your duty to neutrally apply the law of people that are coming before you? So describe to me your method of statutory or constitutional interpretation. How would you carry that out?
Absolutely, Senator. When I am confronted with a statutory or constitutional interpretation case, I take my cues from the Supreme Court. The Supreme Court has instructed in statutory interpretation cases, you first must look at the text, and if the text is unambiguous...
Okay, so what is your understanding of original public meaning?
My understanding of original public meaning is that it is a tool of constitutional interpretation that the Supreme Court has used in interpreting the Second Amendment and the Confrontation Clause, and I would faithfully apply the Supreme Court's mechanisms for interpreting.
Original public meaning seeks an understanding of the statute as it would have been understood by the general public at the time of passage. Okay, let me move on with you for something else. Your previous nominations process, you answered several questions for the record indicating your views on when nationwide injunctions are appropriate. So can you point to any provision of the Constitution or federal law that expressly permits a single district judge to grant relief that is binding on the entire nation? Give me one.
The All Writs Act and Rule 65 and judicial precedents do not foreclose a district judge from entering relief that is beyond the geographical boundaries, but it should be, and as an all injunctive relief, sparingly used because it's a drastic remedy.
But it is appropriate that neither the Constitution nor any federal statute explicitly authorizes district judges to issue nationwide injunctions. Isn't that correct?
It is an equitable remedy that has not been foreclosed.
Isn't that correct? Yes or no?
It is correct that there is no law one way or another.
That is accurate. That is correct. Thank you. I appreciate the time.
Senator Hawley?
Thank you, Mr. Chairman. Congratulations to all of the nominees. Judge Ali Khan, I think the last time you and I visited, it was before the Homeland Security Committee. And I asked you a number of questions there, you, including some for the record, you answered those, which I appreciated. One question that I ask you, and I ask every nominee actually on that committee and this one, is whether or not the nominee has ever litigated against a religious liberty claim. Usually the answer to that's no. In your case, you answered yes, and you listed 1, 2, 3, 4, 5 different cases over a period of years actually in which you have litigated against individuals or churches' religious liberty claims. So let's just talk about a few of those if we could. Let's start with some of your work during COVID. Case you list here, Capitol Hill Baptist Church versus Bowser. Do you remember that case?
Yes, Senator.
You remember working on that case?
Yes, Senator.
This was a case involving the district's lockdown policies that shut down churches in the district. Is that correct?
It concerned litigation over provision of the lockdown policies. The policies restricted all types of activity in the district.
All types of activity in the district?
Yes, Senator.
Did it restrict mass protests in the district?
Well, it restricted activities that one normally expected, including work, going to stores. It also did include these provisions that were challenged concerning churches.
So it exempted unusual or unlikely activities that's in the statute, that's in the ordinance?
When the mayor was enacting these orders at the outset of the pandemic, I think she was trying to be as comprehensive as she could, and the order did restrict a number of daily activities of district residents.
But it exempted mass protests?
I don't believe it said anything one way or another.
Can you point me to the text where it exempted mass protests?
I don't believe it said anything one way or another.
Of course it didn't, because it didn't exempt mass protests, right? You know that.
I think it was silent on the issue because I don't believe it was contemplated by the mayor's office.
Ah, so you think that mass protests should be in a different category than religious observances? Is that your position?
I think if there were protests on the book, then the mayor might have thought about that when she was enacting the COVID-19 restrictions. But I think she was trying to protect public health.
So you think it's fine to say to religious people that they are prohibited from gathering outside, wearing a mask, socially distanced. They can't do it. But if you want to come and protest, defund the police, if you want to support that, that's fine. You can gather en masse, person to person, close up, thousands of people. That's okay. That discrimination's okay. That was your position?
Senator, that is not my position.
It was your position. It's what you argued.
I did not write these orders. What I said.
You defended it in court. And you just articulated to me what I take to be your position.
What I was doing in a Capitol Hill Baptist Church was defending the mayor, my client, against a constitutional challenge to one aspect of the COVID-19 restrictions. We understood that strict scrutiny applies.
How did that case go for you?
We lost that case.
Why?
It was found that the restrictions did not meet the standard of strict scrutiny.
Meaning they were unconstitutional.
Meaning that they did not survive strict scrutiny, and it's a matter of public record that the District of Columbia did not appeal that decision.
Why? Why were they struck down?
Excuse me, Senator?
Why were the restrictions that you defended struck down as discriminatory? Why were they?
Because they did not satisfy.
Why didn't they?
The court concluded that there were restrictions that were not neutral of general applicability.
Yeah. That's legalese. Why didn't they? Why didn't they on the facts? You know the facts. You were a good lawyer. Why'd you lose?
We lost because, applying the strict scrutiny test, the court concluded that the restrictions were not narrowly tailored to serve a compelling governmental interest.
Because?
Senator,
Oh, come on, Judge. Don't make me do this. Do you want me to go through it for you? You lost because Mayor Bowser was going to mass protests herself personally with thousands of people celebrating them. By the way, which is fine. We have the First Amendment in the United States. I want to be clear. That is totally fine. You want to protest? Go for it. I think that's totally fine. That wasn't the problem here. At the same time she was doing that, she was prohibiting churches, religious people, from gathering socially distanced outside wearing masks. And the district court said, you can't do that. That's discrimination. You can't separate people out based on their ideological beliefs or their positions. You can't do that, right? Isn't that what the district court said?
the district court said that
Do you agree with it?
Could not survive strict scrutiny.
For those reasons, right? Why are you fighting me on this? I can't figure this out.
I am not fighting you, Senator.
So yes, you agree. That's what the district court said.
That was what the district court concluded.
Do you think they got it right? The district court get it right?
The district court, we did not appeal that decision. I think that district court decision is consistent with rulings that we got from the Supreme Court clarifying the application of the religious test to COVID-19 restrictions in Tandon and the Brooklyn Archdiocese.
My time's almost expired, and I know other senators want to ask questions, so let me just very quickly here. Do you think it's wrong to discriminate on the basis of religious faith?
Absolutely, Senator.
Why did you argue that religious services, religious people pose a greater risk of infection than people gathered to argue for defunding the police?
I was representing my client. The mayor and consulting epidemiologists had issued orders that she thought were going to protect public health. It was my role to defend those as a
Why did you make that argument? This seems like a strange argument to me, that religious people are somehow, more infectious than folks who have other ideological positions? I don't get it.
My understanding was the nature of singing and other things epidemiologists thought could transmit COVID at a higher rate.
You didn't put any scientific evidence on the record for it?
Senator, those were fast-moving cases, and they weren't going to full briefing and full summary judgment with a record.
That's not what the district court said. The district court said that you engaged in, and your client engaged in, and you defended discrimination on the basis of religious belief, that you offered no scientific evidence for it, that you pressed these arguments over and over and over without any foundation. Frankly, I'm disappointed that you made those arguments. You can choose what arguments to make. I'm disappointed you made those arguments. I'm disappointed you persisted in defending them here today. And for that reason, among others, I will not support your nomination. Thank you, Mr. Chairman.
Senator Tillis.
Thank you, Mr. Chairman. Congratulations to all of you on your nomination. I'm sure you and your families are proud. Judge Munley, I have just a quick question for you, something that came up in reading the background. I think you gave a lecture on communications, and you had a slide that referred to invoking religion could be a sign of deception. Can you just, it was, I could try and find the date, but it had something, you looked with a furrowed brow, so you don't know what I'm talking about?
I do not recall that.
I'll submit it as a question for the record then, so that you can have proper time to look at it in the context. But it really, the question,
Absolutely.
when we submit it for the record, it's really what was meant by the statement. I'm sure, like me, you make a lot of public comments, but I'm particularly interested in how people of faith should interpret the statement. So we'll submit that for the record. I'd appreciate you getting it back. Ms. Alicon, have you written any legal briefs in support of sanctuary city policies?
Yes, Senator. I believe in my time as Solicitor General, the Attorney General joined or authored several of those briefs, and I would have been supporting that.
And what was your thesis put forward?
I believe the cases that the district was drafter on concerned restrictions on Burn Act funding.
I for one think it's odd that, I mean, we're talking about you moving up to a position on the bench, and yet we're arguing this. I just can't. I'm not an attorney, so I'm not going to spar with you. I'll leave that to the attorneys on the committee, but it just seems odd to me that we'd ever be in a position to where we're advocating for a policy that's fundamentally counter to federal law. So help me understand. Just help me understand.
Senator, I want to make clear this was not a decision I made to author these briefs or to join these briefs. The Office of the Attorney General is led by an elected official, the Attorney General, and he sets the litigation priorities for the office.
Okay, so I won't ask your personal view. I know Senator Kennedy did. But what I would like to do, Mr. Chair, if possible, so that we could possibly prevent a second round, is to yield the remainder of my time to Senator Kennedy.
Without objection.
That was nice of Tom. Thank you, Tom. I'm going to send you a fruit basket. Give me that sheet back. Judge Oliver, how flexible must an employer be when a worker asks for a religious accommodation? What's federal law on that?
Senator, in my 14 years as a state court judge and 11 years as a litigator, I haven't had that issue presented to me. I can commit to this committee that if presented with this issue, I'll research it well and be prepared to address it in advance of the proceedings.
So you're not familiar with the Supreme Court precedent on religious accommodation by an employer?
I'm not sufficiently versed on it to be able to answer it appropriately, Senator.
Okay. Tell me about the political question doctrine.
Yes, Senator, thank you for the opportunity. The political question doctrine is the one means by which the United States Supreme Court can decline to act. It indicates that when an issue is before the court that is so inherently political and it's in the process of being considered, that the Supreme Court can decline to act and leave it to the appropriate body.
Okay. Give me an example, if you would, please, Judge.
An example of a political question.
Let me ask you, in preparing for the day today, you met with White House counsel?
Yes, Senator.
And their team? They got a good team, don't they?
Yes, Senator.
Did they give you a list of questions to be prepared for?
A list of some questions, Senator, yes.
How many questions were on there?
How many questions? A few dozen, I would suggest. I would estimate.
Just a few dozen?
Yes, Senator. I think that's accurate.
Okay. And where did they get these questions?
Some were taken from prior public hearings before this body.
My questions?
Yours are on that list, Senator, yes.
Okay. Thank you, Mr. Chairman.
The Kennedy bar exam lives on. Senator Lee.
Thank you very much, Mr. Chairman. Thanks to all of you for being here. Judge Ali Khan, I'd like to start with you. Tell me in one sentence what a judicial philosophy is. What do you think that means?
I think it's the set of principles that a judge brings with them when they join the bench.
How would you describe yours?
My judicial philosophy has three components, Senator. First, the humility to understand that the judicial role is quite limited. Legislatures enact laws, executives enforce them, but the only role of a judge is to apply the law to the facts of the case before them. Second, to make sure that all parties leave my courtroom feeling like they have been heard, knowing they have been respected, understanding that I have been well prepared and asked good questions. And finally, that I issue opinions that are prompt yet thorough and that are written in such a way that both litigants and pro se parties can understand.
What role should the text play when you're interpreting a provision of the U.S. Constitution or federal law?
The text is primary. You look at the text first. If it is unambiguous, that answers the question. That is well settled Supreme Court precedent.
Where there's ambiguity, what do you look to resolve the ambiguity?
So when there is ambiguity, for example, in a statute, you would look to not just the text but the context. If there were, depending on when the statute was passed, looking at relevant dictionaries from the time to understand the public meaning of the words that were used. Also looking at the way those words are used in analogous statutes from the time. Ultimately, once you've exhausted text, context, history, dictionaries, you can look at canons of construction.
But the effort should involve trying to ascertain the meaning of those words at the time of enactment, if a statute, or at the time of ratification, if a part of the Constitution.
Yes, Senator. That's why you look to contemporaneous dictionary definitions.
Thank you. In 2021, you spoke on a panel at an event, I believe, honoring the 20th anniversary of the founding of the American Constitution Society. And in your remarks, you said, quote, "I've been able to think through my job to carry out and live some of the values of ACS." Tell me, Judge, how did you carry out and live some of the values of ACS as Solicitor General and now as a judge on the D.C. Court of Appeals?
The values of ACS, as I understood them, were education and mentorship, and I try to carry those out both in my role as an advocate and now as a judge to make sure that I'm speaking to the next generation of lawyers, to make sure that I keep an open mind, stay current on interesting debates, stay current on the current state of the Supreme Court cases so that I can apply them faithfully to the cases that come before me.
Okay. And what other values might you refer to ACS? Are there others other than the ones you've just described?
I understand from Senator Blackburn there's a long mission statement for ACS. My involvement with ACS has always been on these types of panels where we're discussing legal issues, on mentorship events, when I'm speaking to the next generation of lawyers, particularly about opportunities in public service. And then oftentimes ACS and the Federalist Society will pair up at law schools to have different issues sort of aired and debated. I loved going to those events when I was in law school, and I love speaking at those joint events because I think you're really getting a way of understanding the diverse perspectives of the law. I think that makes us all better students of the law. Obviously, as a judge, my role is just to look at the law and the facts and the cases that come before me. But for those that are still in law school, those that are exploring careers in academia and policy, I think these are interesting debates to be having.
Judge Mundley, what can you tell me in one sentence about removal? Removal in the federal jurisdictional sense of a case filed in state court.
That if a case is filed in state court, at sometimes senators, that one party will file a motion to remove the case for venue purposes to federal court, particularly with diversity cases. I mean, that was more so my experience with cases that I handled as a trial lawyer in state court, that sometimes lawyers on the other side would file a motion to remove the case to federal court for venue purposes, and then the case would proceed in federal court with diversity jurisdiction.
Right. Judge Oliver, what can you tell me about the Dormant Commerce Clause, what it means, what it stands for?
Thank you for the question, Senator. The Dormant Commerce Clause is considered the opposite side of the coin from the Commerce Clause. It prevents one state for attempting to gain a political economic advantage over another state by burdening that other state in a way that the home state's not burdened.
If it does so intentionally, that's one thing. What if it does so incidentally?
I think if it's incidentally, you might look at the text of the statute and determine it that way. It is part of Congress's ability.
The text of the underlying state statute?
Yes, Senator.
So if it's written in facially neutral terms relative to whether it discriminates against interstate commerce, then is there anything left of the Dormant Commerce Clause at that point?
No, I think there's the important factor of intentionality as we're talking about competing economic interests.
Okay. Thank you very much. I see my time's expired.
Thank you, Senator Lee. I want to thank the panelists and all of their family and friends who came in support today. It is interesting when you've experienced many of these hearings, the nature of the questions that are asked. Some of the questions challenge the individuals on the panel because they ask them for personal views on issues, and many are instructed by the canons not to share personal views, but to try to stick with the law and not to prejudice any pending case or any future case. And so it puts many of the nominees in a tough position. We all have opinions on things, but judges do their best to suppress those and follow the law and facts in the case, which they're asked to do. So it creates a challenge in that regard.
Mr. Chairman, may I be heard on that?
When I finish, please.
Sure.
And I also want to say that many people have jobs to do that are created by statute and by law. For instance, to represent certain clients, Solicitor General would be representing, in some cases, the views of a mayor that are expressed through policy and through ordinances and laws and the like. They may not be views that you personally share, but as a litigant, you have a responsibility to be loyal to your client, not to allow them to lie or have anything they say that is misleading be part of the record, but to honor them and defend their position. One member of this panel said, and I think properly, as a litigator, you do not necessarily share the views of the people you represent. In fact, very often, having been a litigator myself, I would say that you may disagree quite strongly with the views of the people or the litigating positions, even of the people you represent, but it's your job to represent them effectively and fairly. That was the senator from Missouri, and I think he was right in the citation that I've just read to you. I could go through the panel and say that depending on the nominee, each of us has said something like that. You do your best for your client, even though you may not agree with their fundamental policy views. You have a responsibility to represent them effectively and professionally. Senator Kennedy.
Thank you, Mr. Chairman. I agree. I concur in part and dissent in part with our esteemed chairman. I think he's right. We're all attorneys. We've all had clients we didn't agree with. Hell, we've had clients we didn't like much. But you do your job as long as it's ethical. And I can't recall a time that I have really pressed a nominee on a position that nominee took on behalf of a client, if I thought it was in good faith. I disagree with our chairman that your personal beliefs don't matter. Those of you who I questioned today, I specifically asked you if you'd allow your personal beliefs to influence your decisions, and you said no, and that's as it should be. But if you don't have personal beliefs, and you're not qualified to serve on the federal bench, you're just not. If you don't have personal beliefs, you're not a critical thinker. If you don't have personal beliefs, you haven't examined the world. You've just been robotic, doing what somebody told you. I think your personal beliefs do matter. And I think you ought to be able to discuss with us things like race in society, things like when does life begin? These are things that we all grapple with as Americans, as human beings. We need to talk about when does equal protection of the law attach to a person? Does it attach in the womb? Should it attach in the womb? We need to talk about racial progress in America, what we've gotten right, what we've gotten wrong. America caught the disease of slavery, but we beat it back. We should be able to talk about that. I've never asked your opinions or a nominee's opinions about a case that was pending before them or that might be pending before them. But when you come before this body, at least this is one person's opinion, when you come before this body and you refuse to answer a question about your personal beliefs, people are going to assume what they want. And sometimes they're going to assume correctly, and sometimes they're going to assume incorrectly. But they're going to assume, and they're going to attribute that belief as your belief. So I think you're making a huge mistake. I understand I've served only with 2 presidents. White House counsel's offices do their job. They get you prepared. They give you the questions that have been asked in the past. I get all that, okay? But I just have to dissent from my chairman that your personal beliefs don't matter, because they do. They do, a lot. And they tell us a lot about you. Thank you, Mr. Chairman.
Senator Kennedy, I respect you much, and I count you as a friend, but you and I both know the experiences we've been through in this committee. Nominees, potential nominees, even for the highest court in the land, would not take a somewhat neutral position saying, as a judge, my personal views don't count. They instead give us obfuscation. We've seen it happen on both sides of the table. You would think an issue as fundamental and basic and as well-known as the issue of abortion would be one that you could express yourself on, where you stand, what you feel. But many, including nominees for the Supreme Court, would tell us, oh, you're talking about established law and established precedent. Then along comes the Dobbs decision, and you say, what is this all about? This isn't what you promised was going to happen. It didn't come out that way. So I understand nominees are in a difficult position. They're trying to follow the canons as they understand them as nominees and as sitting judges. And they don't want to prejudice future cases or pending cases that they might sit on. So that's just part of this process that both sides will use to their advantage when possible. And I respect you. I think you're a person of value and principle, but we disagree on this.
Well, Mr. Chairman, if I could just respond, though, to that. And Dick, I appreciate that point of view. I think Supreme Court nominees are in somewhat of a different position because they're going to be making the ultimate law of the land. I think lower court nominees are not in the same position. And I just don't see what we gain by not being able to talk about what people believe. I mean, I would like to hear what thinking people believe about, for example, is sex a biological fact or a social construct? I mean, I assume all of you have thought about that and have an opinion. I would also point out, Mr. Chairman, this isn't a criticism, you're following past precedent. But each one of these individuals, if they're confirmed, are unelected. They're there for life. For life. And we're not allowed to talk about what they believe. And we're only given, again, this isn't a criticism, 5 minutes?
Well,
come on.
By that logic, if you apply it to the highest court in the land, how many of them have been in elective office?
Some haven't.
Most haven't.
But that's why we also have, well, Earl Warren was, but that's why we also...
You have to go back in history.
That's why we also devote days to a Supreme Court hearing.
Yes, instead of 5 minutes, we take 15.
As we should.
Yes.
With second and third rounds.
Well.
But anyway, Mr. Lee, my good friend, wants to say something.
I have to be at a place right now, so please.
I will be brief. I just wanted to respond to the point about Dobbs. I've heard some colleagues say this, sometimes in the context of this committee's work, sometimes in other contexts, that there's this suggestion made that because nominees came forward and acknowledged that Roe versus Wade was established precedent, that somehow locked them in, and that they had, under oath, somehow betrayed their obligation to testify truthfully under oath. For every hearing that I've been a part of, and I've been here for 4 Supreme Court confirmation proceedings, not one of those justices who has been complained about, in the wake of the Dobbs decision, said that Roe or any other case was unassailable on any grounds ever, or was somehow protected under the doctrine of stare decisis from the possibility that future courts could conclude, as the court did conclude in Dobbs, that Roe versus Wade was without textual foundation in the Constitution, that it was without the kind of foundation that could make it a part of the constitutional analysis, not rooted in our nation's history, tradition, and so forth, as a matter of due process. Now, I take issue with the suggestion that any one of these nominees misrepresented in any way, shape, or form their views on the Dobbs case. They could not answer further questions about whether it was assailable under a challenge, and they made no representations as to how it might fare under the doctrine of stare decisis. Such questions, when asked, are questions that they're understandably not allowed to answer under the canons of judicial ethics. Thank you.
So as chairman, you take the last word. The people who were appointed to the Supreme Court by the Trump administration were pre-cleared for one purpose, to overrule Roe versus Wade. The Federalist Society, which was the secret handshake for every nominee who came before us from the Trump administration, was established for that purpose. We know that. Regardless of the questions answered here in the Judiciary Committee, we knew what they were aiming for, and they finally reached that goal with the enactment of the Dobbs decision. But if you listen to their testimony before this committee, they carefully misled us or obfuscated the situation. You may disagree with me, but that's my opinion. I look at it and I thought to myself, I know where this nominee stands, and I'm not going to name names, based on their life experience and where I've seen them rule or speak in the past. That's just the nature of this process. As I said, I get the last word because I'm chairman, so thank you. We'll carry on this discussion, I'm sure, beyond today. Thanks again to the nominees, their family, and friends.
Well, Mr. Chairman, with a bold statement like that, I think you ought to let Mike respond. I don't think that's fair.
It's just not accurate. In
That's a pretty
no
bold
respect,
statement.
you have defamed them. You have accused them of committing a crime here. That is a crime to testify falsely under oath. They did not do that. I challenge you to find one statement that you could defend as knowingly false made by them, as perjurious. That's what you've done. That's not appropriate.
I said they selectively misled. I didn't say whatever you just said, feloniously.
From an ethical standpoint, that has the same effect, and they did not do that.
Without describing one another as defamatory. This meeting stands adjourned.